Thank you, everyone. Welcome back to the Minnesota Senate and the legislative session of 2022. Today, this committee is the Senate Judiciary and Public Safety Committee. And today's, for the record, is Wednesday, February 2nd, 2022. And let the record show that we have a quorum. We have two bills in our agenda today. And I believe we'll start out, but I do want to review hybrid hearings a little bit so we know kind of the rules that we have to work with in order to make it work and make our effort and our work available to the public. A hybrid hearing is essentially a Zoom meeting with several people sitting in the same room, allowing for in-person and remote participation. And there are just a few ground rules that we should have before we get started in today's agenda. In-person members need to be logged into the Zoom meeting on their laptops and have your cameras turned on, but your computer and Zoom account muted. You will speak into the committee room microphones. Remote members will need to have your cameras turned on, and you will need to unmute yourself when you speak so other participants can see and hear you. Voting procedures for a hybrid hearing are essentially the same as they are for remote hearings. Before a voice vote, I'll ask all members to give both a verbal and visual cue, such as thumbs up, raised hand when you vote. A roll call vote is similar to in-person hearings. I will note when a roll call is requested and will be granted, and then I'll ask staff to take the roll. All amendments released to committee staff ahead of the hearings will be posted on the hearing notice and distributed in committee packets. If a member offers an amendment that was not released before the hearing, the member should clearly identify the amendment. Senate Counsel will then email an electronic copy of the amendment to the committee email group. Meanwhile, partisan committee staff will post the amendment on the hearing notice so that it's publicly available. The page will also distribute physical copies of the amendment to in-person members and staff. I'll begin discussion when all members have received an electronic copy of amendments. And with that, we can begin our first bill. I'm going to hand the gavel over to our Vice Chair, Senator Johnson, since I will be presenting the next two bills.
Thank you, Senator Limmer. Let's begin then with Senate File 2672. As I understand it, you have the A1 amendment. Would you like to move that?
Yes, Mr. Chairman. Looks like a typographical reference. It's author's amendment, the A1.
All right. Thank you, Senator.
I move the A1, Mr. Chair.
Thank you, Senator Limmer. All in favor of the A1 amendment, say aye.
Aye.
Aye. All opposed? Amendment passes. Senator Limmer, to your bill.
Thank you, Mr. Chair and members. Senate File 2672 is a bill that would require confirmation of members of the Minnesota Sentencing Guidelines Commission. I'm planning on bringing this bill forward with a few thoughts in mind. Foremost is the separation of powers concern. The Minnesota Sentencing Guidelines Commission is, lost my place temporarily. We have the Minnesota Sentencing Guidelines Commission is one that has members that are appointed mostly by the executive branch. There are 3 members out of 11 that are appointed by the Judiciary, by the Minnesota Supreme Court. But the remaining are members that are appointed by the governor himself. The vast majority that serve are unelected individuals in that appointed capacity. And in my opinion, they have no true accountability like we would have directly to the people of Minnesota. Unlike us, we stand for election every year, and we're held accountable to the job that we have. They do not. When this has been the case with other boards and commissions, the legislature has seen fit to require confirmation on a variety of other boards and commissions. And that confirmation is done by the members of the Minnesota Senate. I'm simply extending that same concept to the Minnesota Sentencing Guidelines Commission in this proposal. As a background, I did go through the membership, and again, I just wanted to repeat that 3 members who serve on the commission are from the Judiciary branch, and the remaining 8 are appointed by the governor to 4-year terms, and those terms run in coincidentally with the governor's term in office. So every time there's a governor, there is the possibility of getting 8 new members. My concern is that the Minnesota Sentencing Guidelines Commission has increasingly become more interested in writing policy, mainly modifying or reducing criminal sentences that are already written into law by the legislature and approved by a signature of a governor in the past. I find that to be somewhat alarming. These changes would reduce sentences for repeat criminals and threaten the safety of Minnesotans during a time when repeat offenders are adding to very high, record-breaking violent crime rates in Minnesota. The most recent decisions was one in 2019 where the Sentencing Guidelines Commission capped the length or the term of probation for almost every kind of crime to a period of 5-year maximum. They're now contemplating changing the custody status point. That's a point, criminal history point, or a half a point, that is, in the event that someone would commit a crime while on probation. This also causes a slight ripple up and down the sentencing guidelines grid. And even proponents of that change has said that that would cause the release of approximately, or over 500 inmates in our prisons at that time. I think, again, this is alarming. Well, as we go forward on it, today's bill focuses on whether the individual commission member should be vetted by the Senate, not just by the administration, the executive branch, and that it seek confirmation for this type of a commission. And with that, it's a brief description, Mr. Chair, but nevertheless, I'll stand for discussion.
Thank you, Mr. Chair. Appreciate that explanation. Members, any questions regarding the bill? Senator Latz.
Thank you, Mr. Chairman. I guess a couple of questions. First of all, I know the practice in this committee in recent years has been to not hear bills that don't have a House counterpart. And in fact, we've been told repeatedly over the years that we couldn't consider proposed policies, bills that were introduced because they didn't have Senate counterparts. If the House was going to come over with bills that were in their packages for negotiation at the end of session, it was a consistent line that we were not going to consider those because the Senate didn't have an opportunity to review, consider, have hearings, evaluate, maybe pass out of this committee, maybe pass off the Senate floor because it wasn't a Senate counterpart. Well, unless I'm reading it wrong, our system here indicates there is no House bill that's been introduced to do this. At least there wasn't yesterday when I looked it up online. Can we be informed what the current status is? Is there a House counterpart to this bill?
Mr. Chairman?
Senator Limmer.
Mr. Chairman, thank you. Senator Latz, I believe it's House File 2962. There is a House counterpart to this bill. And by the record, it was introduced yesterday, February 1st, 2022.
And Mr. Chairman,
Senator
Do you
Latz.
have any indication of whether or not the House intends to give it a hearing?
Senator Limmer.
Mr. Chair, Senator Latz, I do not know what the intention is of the Minnesota House. Quite honestly, we have our work to do, they have their work to do, and it's up to that particular chair to choose whether or not they give that a hearing. I don't have an answer for you at this time.
Senator Latz, follow-up question?
Thank you, Mr. Chairman. A little bit separate topic. The opening remarks by Senator Limmer indicated that the governor appoints 8 of the members of the 11 members of the commission. As I'm reading through the statute, technically I see that as true, but only 6 of the governor's appointments are sort of direct and chosen directly by the governor. The 2 of them must be upon recommendation of 2 other bodies. So the public defender is appointed by the governor upon recommendation of the state public defender, and the county attorney is appointed by the governor upon recommendation of the board of directors of the Minnesota County Attorneys Association. So I suppose the governor could theoretically take the recommendation and say, I'm not appointing that person, send me someone else that's more acceptable to me. But it's not unfettered discretion on the part of the governor. I think it's worth clarifying that only 6 of the 11 appointments are, in that sense, unfettered, and there's even some limitations on the types of people there. One has to be a peace officer by statute. One has to be a probation or parole officer by statute. Of the 3 public members, one must be a victim of a crime, a felony crime. This law was originally passed in 1978. I haven't looked to see exactly what the terms are, but it's been 30 years or so, more than that. And the statutory makeup of this commission is, it seems to me, intentionally broad by definition, and was intended to bring a diverse set of viewpoints and perhaps philosophies, stakeholder interests to the table, so that there could be a wide-ranging input on the commission and a wide-ranging conversation, and ultimately, if they were able to achieve a majority, a consensus on how to move forward with any proposed changes. So I guess I wanted to point that out. In addition, Mr. Chairman, I will note in subdivision 5 of the authorizing statute for this commission, the guidelines promulgated by the commission shall be advisory to the district court. So there is, by definition, and those of us who are familiar with the way these guidelines are implemented, the district courts have a wide range of discretion in how they will handle and apply these guidelines, including the application of lengths of probation, sentences, which fall in different places on the grid. There's a midpoint that's identified. There's a bottom of the box sentence. There's a top of the box sentence, all of which is within the court's absolute discretion. And then they're to tailor according to the situation before the court, which includes the nature of the crime, the input from the victim, characteristics of the offender, characteristics of the crime itself. And then there's a pretty, I don't know if fluid's the right term, but a broad description of situations in which a judge is free to go outside the sentence that is part of the guidelines grids, to depart upward or depart downward. And there's a lot of discretion which is afforded to a judge that makes the determinations on that topic to depart. In fact, the Court of Appeals standard, I think for most of these determinations, is the abuse of discretion standard, which means that unless there is really no basis in fact for the district court judge's sentencing decision, or if it's clearly contrary to law, then the judge has the discretion. So it really does mean that even probationary caps, and I suppose I can get corrected at the appropriate point by Mr. Wrights when he testifies on the next bill, if I'm wrong about any of this, but I think even probation caps, with the exceptions that were in place, by the way, in the guidelines commission's determination there, even those ultimately would be advisory to a district court judge in deciding what sentence to impose. I would also note that the legislature very intentionally and statutorily retained authority to override any decisions that the Guidelines Commission made. And I don't have the statutory cite. Oh, there it is. I think subdivision 11. Although I'd be corrected if someone had the actual cite. The guidelines that are proposed by the Guidelines Commission can be overridden by the legislature by us simply passing the bill signed by the governor to do that. So I don't see that technically there's any separation of powers issue here. We've retained the ultimate legislative authority over any of this. So while it might be a term that can be referenced as a separation of powers, I don't think it really is. The legislature intentionally delegated this highly technical, highly complex decision-making or promulgation of the guidelines to this particular commission, which brings a lot of its expertise in the field to those decisions. Because it's precisely because it's not the kind of thing that is easily dealt with in the legislative branch. Unless we want to meet year-round, unless this committee wants to meet a couple times a week year-round, we don't have the expertise nor the time to be investigating and making decisions about the complex issues that go into sentencing guidelines decisions, let alone making sure we have all the proper stakeholder input, which is only informal in our committee process. It's at the discretion of the chair, what witnesses to allow to testify, for example. In fact, the last committee hearing that I attended, looking at the causes or solutions to some of the criminal activity that was going on, there were only law enforcement officers invited to testify, and it was explicitly stated ahead of time that no one else from any other stakeholder or interest group or viewpoint would be allowed to testify at the hearing. And there were a number of us raised questions about that, wanted to have additional viewpoints brought in, but they were not allowed by the rules that were set for that particular hearing. Different than that, the Guidelines Commission, by definition, has a wide range of stakeholders at the table. They are entitled to present their viewpoints and ultimately to vote on the changes that are made. I would also note that the Guidelines Commission was intentionally set up for, I think, two main reasons. One was to bring some consistency statewide in sentencing, because as the committee knows, judges in different judicial districts in different parts of the state, they had somewhat different practices even today, and the statistics that we've been presented by the Guidelines Commission in the past has shown that sentencing practices around the state vary. sometimes substantially, as much as twice as long a sentence for some offenses, some parts of the state than in other parts of the state. But it was at least intended to give some consistency to the sentencing across the state. So people who committed a crime that was similar to a crime committed in any other part of the state would receive, within range, a somewhat similar sentence. Parenthetically, that is disrupted by the whole concept of mandatory minimum sentences, taking some of that discretion out of the hands of individual judges, and also disrupting the guidelines grid itself, because it superimposes other mandates and standards into the guidelines determination process. So actually, it's the legislature that creates, in some sense, disruption to the overall consistency intended by the guidelines. The other reason I think the Guidelines Commission was set up was to take it out of the partisan battles that the legislature inherently gets involved in, because we are inherently a political body. I mean, by very definition, and particularly in election years, like this one. We've already seen some of the Sentencing Guidelines Commission's discussions, let alone decisions, being highlighted as part of the election campaign messaging, and I think that's probably not going to change this spring. But it belies the entire purpose of having an independent commission, evaluate and make some recommendations or advisory decisions as part of their process. So I have one other, I guess, main point I'd like to make on this. We're looking at, probationary caps, we're looking at custody status points. Actually, I have a question on that. I don't know the answer to this question, honestly. A good lawyer doesn't ask a question they don't know the answer to, but I'm going to ask it anyway. Senator Limmer made a statement that he was told that if the custody status point changed or maced, it would result in the release of 500 inmates. And my question, was that a release of people already in custody, or was it, which would require a retroactive application of that rule, which I think was a contentious point in the discussions about whether even to do it. But the second point was, or would it result in 500 fewer commits, because in subsequent cases it would not result in commits to the prison system? So I guess that's a question. I'll have a follow-up comment on that.
Thank you, Mr. Chairman. Mr. Wrights is in the audience, but the figure that I was relying on was from a figure that was printed by the Sentencing Guidelines Commission, a recent publication. And there was retroactivity involved in it, and the figure of over 500 possible releases was their figure that I'm quoting from. Ms. Wrights, would you have any addition to that, or could you clarify where that figure came from?
Please state your name for the record.
Thank you, Mr. Chair. My name is Nate Wrights. I'm the Executive Director of the Minnesota Sentencing Guidelines Commission. The figure referenced is a staff estimate of the impact of the original proposal, which was that it's similar to the way we do fiscal notes. We estimate the prison bed impact of a crime bill. We estimated the prison bed impact of the policy that was being proposed at that time. Our original estimate was that the policy, if implemented, would reduce the number of eventual prison beds needed by 536 beds. We later changed our assumptions. So that was the figure that went to the public hearing based on revised assumptions, based on essentially a revision of what the status quo was, based on some understanding of Court of Appeals handling of the existing guidelines. We changed that to 499 beds. But there was no discussion about making that retroactive. It was an estimate of the prison beds that the change in prison bed need that would result in the future.
Thank you.
So, Mr. Chairman?
Senator Latz.
So it sounds like it would not result, if that change were to become effective, it would not result in the release of any current inmates because it would not apply retroactively. The bed impact would be prospective, meaning there are people who, under the current practice, would be in the future committed to prison that, if this change were implemented, were anticipated would not be committed to prison. So there would be, that would be the impact. Is that correct, Mr. Wrights?
Mr. Wrights, you can answer. It feels like we're getting a little far afield of the bill here itself, but we can continue. If you can answer that, maybe we can move on from there.
Thank you, Mr. Chair. Senator Latz, that's correct. If there were to be any kind of retroactive application, it would have to be done by an entity outside the Sentencing Guidelines Commission. The Sentencing Guidelines Commission never contemplated retroactive application. I should say that the proposal under consideration was, at least for the time being, rejected by the commission unanimously at its January meeting. So that is currently not the active proposal that's being considered by the commission.
Thank you. So, Mr. Chairman,
Senator Latz.
I'm going to loop this back in because these two topics seem to have been a motivating factor in bringing this bill forward. In fact, Senator Limmer identified them as points of concern at his press conference earlier today. He said it raised alarms, or red flags, if you will. The probation cap, which is a whole nother discussion, but setting it at 5 years was intended from the discussion at the Guidelines Commission and their justification for deciding. There were some places were sentencing people to 20 years of probation for the same offenses that were being sentenced to 3 or 4 years of probation in other parts of the state. So actually a probationary cap of 5 across the board is theoretically similar in a sense to a mandatory maximum, or same concept as a mandatory minimum in some senses for creating some uniformity across the state and getting rid of the extremes. But the point is those two proposed policy changes were being weaponized, are being weaponized in this proposal here as a justification for changing the commission from its current setup to requiring Senate confirmation. In other words, there are some disagreements over the policy direction of the commission, which have led to this proposal to try to rein in the members so they won't make those changes. They would fear for the validity or ongoing value of their appointment were they to support changes in the future under a new statute such as this bill proposes, and that confirmation prospect could be held over their heads, subject to the bully pulpit of the partisan legislature, and especially in election years, to cause them to think about the political ramifications and whether or not their own appointment will survive, rather than thinking about the objective merits of the policy itself. And we need only to look to this very Senate in the last number of years since Governor Walz became governor to know that that is precisely the way this legislature can and has acted. The confirmation process in the hands of this current majority has been weaponized rather than doing a sort of setting a minimal standard of qualifications with a traditional amount of deference to the governor to have the power to select his, someday her own appointees. This legislature, this Senate, has refused to confirm or even take up most of the appointments of the Governor Walz to his cabinet. They've affirmatively rejected a couple of those appointments based upon not incompetence, but differences in policy. It's probably not the way has been characterized in some cases, but we also know that there have been a lot of discussion about other commissioners and disagreements over the way they're approaching the policy decisions in their job. and suggesting that their confirmations may be at risk as well. Quite candidly, I don't think that's the appropriate role of the Senate in the confirmation process, but it's a cautionary tale about giving the Senate any additional confirmation authority when, at least and from my perspective, it has been sorely abused by the majority of the current Senate. So I think it would be a tragedy to start bringing a commission like the Sentencing Guidelines Commission on an issue that is so fraught anyway and subject to political demagoguery, to bring them under confirmation, and then have the prospect of the Senate holding their confirmation, members' confirmation over their heads to try to make sure that they vote the right way according to whoever the current chair is of the Judiciary Public Safety Committee at the time. So that's not bringing the power back to the people, that's bringing the power back into the hands of partisan political electioneering, and that would be exactly the wrong way to go with criminal justice policy in Minnesota. So as for me, I think this is it's a bad bill, and we ought to be opposing it. Thank you, Mr. Chairman.
Thank you, Senator Latz. Senator Matthews?
Thank you, Mr. Chair. First off, I would like to request a roll call on the bill.
Roll call requested. Roll call granted.
Thank you, Mr.
Chairman,
Chair.
point of order.
Senator Latz?
Oh, never mind. I withdraw the point of order.
Okay. You questioning three hands or not?
Not necessary unless there's a request to put it in the journal. So
All right. Thank you, Senator Latz. Senator
part of
Matthews?
that after I inserted my point of order.
Thank you, Mr. Chair. So I want to point out some of the reasons why we've brought this bill forward, and I'm happy to be one of the co-authors on this bill. And we heard a number of reasons laid out, ranging from particular process questions all the way to broad-ranging policy discussions and ways that we've handled confirmations in completely unrelated areas to this one. And the reason why this bill is being brought forward is the point was made earlier that the commission is intended to be a nonpartisan commission in viewing this particular topic of sentencing guidelines. And it's a growing opinion, this is the reason why I signed on to the bill, that the commission's been failing at that goal. That the board right now is made up of, why is this board made up of an overwhelming number of gubernatorial appointments when there are hosts of commissions that the legislature sets up that from the get-go have members put on by the majority parties of the legislatures, members put on by the minority parties of the legislatures, and that commission is tasked with go study this viewpoint from multiple perspectives and come back to the legislature with one recommendation out of that commission. The sentencing guidelines has not done that. I was not here in the legislature when this statute was enacted. If I were, I would have opposed setting up the sentencing guidelines as they are today. But with the makeup being largely by gubernatorial appointment, they have largely just represented one viewpoint. And bringing it through a Senate confirmation process will give the opportunity of expanding to multiple viewpoints, that senators from every part of the state have the ability to bring input on confirmations and urge the governor to make more diverse appointments than he's made so far. This fact that the commission has largely just had one viewpoint was reaffirmed to me when the recent proposal came before the Guideline Commission with an overwhelming number of negative feedback comments submitted to the commission saying, don't do this, don't make this departure, defeat this motion. We don't approve of the way that you're proposing to go. It was amazing to me that the Sentencing Commission could not even bring themselves to defeat the measure. It appears to me that they punted it down the road, perhaps to wait and see if the fervor will die down and try again at a later date. I hope I'm wrong on that, but that's what it seemed to me at the time. And just the concept itself of the commission can redo statutes, and it goes, the legislature reserves the option to overturn them with a brand-new law after the fact. If that seems okay to you, go repeat that to yourself in a mirror until you realize what's wrong with that sentence. Do we give the Data Practices Commission that we just formed, Mr. Chair, you and I are back on that together, do they have the ability to change the state's data privacy laws? And after the fact, the legislature can come back with something to veto the decisions they made. I could go down the list of basically any committee, why these commissions don't come. They should do their work and give their recommendations like we have in so many other areas. But the status quo as it is not acceptable. It's been reaffirmed that way over and over again, more recently than it ever has been before. And this is one small measure alternative to try to bring a measure of balance back to the decisions this body's made. I think we could go a lot further if I had my way just myself with the commission. It would radically look different, but I believe this is a small step and why I gladly signed on to co-author this bill and why I urge members to support it. Thank you, Mr. Chair.
Thank you, Senator Matthews. Senator Kiffmeyer.
Thank you, Mr. Chair. So when I hear the debate here, and I think the points made by Senator Limmer and Senator Matthews are incredibly valuable, and I think take a legislative perspective to something that has gone amiss in regards to the commission, and the roots of it, of course, in the statute, but then also the practice. If they had stayed true to where, when they were set up, this maybe wouldn't be an issue, but it isn't. And so I think acting in a legislative manner as they are now, then it is time to actually have legislative oversight stronger, and especially through confirmation of the members, as many other commissions have, and some other issues as well. I just do want to speak, though, to the fact that when somebody takes a position and they happen to have a political title after their name, to start questioning motives, even though we're not on the Senate floor, gets to be a little problematic for me. I think we really need to stay away from that. And you may agree or disagree with the ideas, but motives is a whole different thing. I think that's one of the strong points, here of the Senate. But I've often wondered, why do we even have the Sentencing Guidelines Commission? Because I hear just recently, well, they can just, any judge can just overrule these sentencing guidelines. They don't have to follow them. Well, that's not quite what I heard. They were like guidelines and some of this. So, and I don't know in practice that indeed is the case. But if that really is the case, then maybe we don't need a Sentencing Guidelines Commission at all. Let's let judges and prosecutors and public defenders work this thing through and apply the matters of the law without having a guidelines kind of commission. So it's maybe its usefulness has run its course. But I think in the meantime, art if possible right now in the legislature, something like having confirmation hearings, I think would be a very reasonable approach for having oversight and also adding other viewpoints to a situation. I think that would be an excellent step to take. Thank you, Mr. Chair.
Thank you, Senator Kiffmeyer. Senator Begum, I apologize. I skipped over you. You go ahead.
Oh, thank you, Mr. Chair. One, good to see everybody. Hope everyone's doing well and safe. So a couple things. Are we going to hear from the executive director on this bill? I think that would be prudent to the author request. So I certainly would have questions. But there's been a couple things suggested about not why do we even have the Sentencing Guideline Commission. And I know I watched a press conference by someone today because I'm going to respect the motive thing that Senator Kiftmeyer said, that talked about concern of policy making from the Sentencing Guideline Commission. So on January 14th, this committee received the commission's report. So one, I want to thank folks that put that together. And it reads, in 1980, and I do know that Senator Matthews Johnson and I probably don't remember 1980, although, I mean, Matthews was here, I digress. Minnesota became the first state to implement sentencing guideline structure. The Minnesota Sentencing Guideline Commission is a legislatively created body whose purpose is to establish and improve the Minnesota sentencing guidelines, evaluate outcomes of changes in sentencing policy, analyze trends, and make appropriate recommendations, and provide education on sentencing law and policy. And then it goes into, say, talking about the standards that should be rational and consistent, and the tools that they use. To Senator Matthews' point, I actually, I'll admit this, I also have concerns about the Sentencing Guideline Commission. But what Senator Limmer and folks are not, what you're proposing here is nothing but political theater in a way that will not get to what I think we could have a legitimate discussion on statutorily. For example, you mentioned one. We should have a discussion about maybe the Senate majority party, House majority party get to appoint people. Because then you get to bypass this whole show. So, and who's ever in charge gets to appoint, gets to appoint the person, right? So I think, a couple other points I want to make. I think it's important to note that most of these, and this is where the executive director would come into play, but I believe most of these decisions by these professionals on the board that are set in statutory guidelines are unanimous. A lot of them were, you know, throughout the years have been more or less unanimous. I mean, yeah, there's some differences, but most part unanimous. When we're talking about confirmations, I don't think it's a secret that the majority party hasn't done their job with confirmation. So I don't know why you're adding to the list of things to confirm when we can't even do the list that we have now to do. So I worry about that, and I worry about the fact that this isn't a solution for it. Today I watched the press conference of the Richfield police chief. Yesterday, as we all know, there was a tragedy, just a tragic incident at Richfield School District in Richfield School. And a 15-year-old boy was shot and killed. And the police chief said the reason they were able to apprehend the two shooters so quickly wasn't because of sentencing guideline stuff or whatever we're doing next. It was because of data sharing. So why don't we focus on issues that we know will make this community, our communities, more safe, like data sharing, like adding more police so they can do the investigation, bring justice to victims, and keep our communities safe? Why are we wasting time on something that is not going to immediately have an impact on what we're doing? And as Senator Latz so eloquently pointed out, this isn't a retroactive, this is proactive. So I'm here to work with you all on that side of the aisle because I think we could have some legitimate concerns. I was born in '79, so I'm not going to say that this is an old commission by any means, but it could probably use some looking at. But it has to be done in a fair, neutral, and transparent manner. I would like to hear from the executive director whether he thinks this is a good idea for the commission to move forward in. That would be my question, sir. Thank you.
Senator Begum, we will open this up to Mr. Reitz here after a moment. I've got a question from Senator Ingebretson right now, and then we'll move over for your testimony. You can remain there at the table.
Thank you, Mr. Chair, and been interesting comments here with regards to political fodder, this and that, weaponizing. I think we're kind of looking at the wrong words being used when we talk about weaponizing, when all you got to do is turn the TV on and all you see is more weapons and more weapons and more weapons and people becoming victimized. And I see headlines all the time about this person was convicted 5, 6 times and released back into society. And if they would have just been put in jail and rightfully put there for the crimes that they actually had committed, that this wouldn't have happened and that wouldn't have happened. It'll be interesting to see about the shooting yesterday. Be interesting to see the suspects that are arrested. I don't know who they are. I have no idea. I have no idea what the motive was. But I'm guessing they're going to have more than a couple parking tickets on their record. I think that's fair to say. Chair Limmer, I'm glad that you brought this forward. I think the public is glad that we're at least starting someplace here with what's going on, the mayhem, the repeated offenses that are going on in our state, primarily within the 7-county metro area. And it's not just the metro area anymore, it's the suburb area now. We're seeing it, Richfield, we're seeing it in different areas where more serious crime is going on that was not happening other than the last couple of years, which by the way, since Governor Walz actually was elected, we've seen this really crime has really taken off. Putting it politely, am I going to blame Governor Dayton? No, I can't blame Governor Dayton. I can see that the legislature has to play a role here because it's not getting any better. Senator Bigham, you said we're going to be changing statutes. We do this all the time. We change statutes all the time if they're broken, if things aren't working. I guess I too would like to ask the question, and I will, of the director. What is his thoughts of crime over the last years? Has it gone up or has it gone down? Has the commission got more liberalized? Has there been more probation than there has been in the past years when I would say the 80s and 90s? I don't have my stats with me or anything at all. But, you know, we all say it's just a pendulum that's going to swing and it's going to swing backwards. Well, the pendulum is really taking a toll on Minnesotans right now, and they're looking for something, and they're looking for some guidance. And with regards to the bill, why wouldn't you, as a governor, why wouldn't I, if I put myself in that position, which I will never do, and some at this table would agree that'd be a good idea not to, but why wouldn't I want somebody else? Why wouldn't I want to say, let's have a little more of an objective appointing process here? I don't care. I don't care if it's a governor with a D by their name or an R by their name. Doesn't matter. And the Senate, I take very strong pride in deliberation when we finally get around to appointments. And are we doing a good job of appointments and getting that done? About the same as everybody else. I've been in the majority for 8 years of my 16 years here, and minority for 8 years. I didn't see everybody when I was in the minority jump all over that and get that done in any real quick fashion. In fact, I know there's other in the environment, some of the appointments are not done yet. You know, that's just not the excuse here. What the public wants is they want something, and they want it right now, and they want to get stiffer and tougher on crime. Now, whether you want to hear that or not, that's what everybody's saying where I come from. I don't think I have to walk too far down the street down here and walk into a house and say, do you think it's safe to walk on the streets here in Minnesota, in the metro area? They're going to say no, and that's really a shame. It's really it's just a crying shame. Prosecutors aren't prosecuting. It has to stop, and this is just a tiny spot where we can make a difference moving forward, at least showing the public that we're doing something. And I expect there's going to be a lot more after this. So with that, I'm just going to, leave the comments like being weaponized, political theater, all that stuff. The theater that's going on in the news is what we don't want to see any more of. And it's up to us to get that done and to do something about safety. So Thank you, Chair, Mr. Chair, for bringing this bill forward.
Thank you, Senator Ingebrigtsen. And I would, if we could just for a moment here, focus back onto the bill. Really the operative language, if you want to just review that quickly, is 2.5 through 7, where it says appointments of members, so on and so forth, made by the advice and consent of the Senate. That's what we want to focus on today. Let's keep our testimony and our comments tight to that if we could, please, so we can have the debate on the substantive policy within this bill. I'd appreciate that. Senator Latz.
Mr. Chairman, I appreciate that, but Senator Ingebrigtsen just, in his remarks, pointed out all of the ways in which this is being completely politicized and not focusing on the merits. Blaming Governor Walz for the rising crime following the George Floyd murder and the civil unrest and the pandemic, which is happening, all of which is happening across the country, to somehow blame it on that, to saying that changing the appointment process to this commission is going to have any effect whatsoever on increasing penalties, reducing penalties, changing this or that, that's going to have an impact on some kid on the street that's deciding whether or not to go commit a crime. It stretches beyond the imagination of possibility. Instead, it sounds like just the talking points of the GOP majority in the election, for the election in November, which bears no relationship to the bill that we have before us here today. So I appreciate, Chair wants to keep this focused on the bill. Let's at least keep it somehow tenuously connected in a causal connection to what the impacts could be.
Thank you, Senator Latz. I completely agree with you. Let's keep it focused, so thank you. Senator Limmer.
Thank you, Mr. Chair. This has been an interesting conversation. We've gone global on accusations already, and it didn't come from our side. As we look at this, I can't help to think that someday there may be a different governor and a different political party in the governor's office. And the appointment process that a governor has right now may be reversed. Sentencing Guidelines Commission may have an opportunity to change in a far different way, which may cause concern for an opposing party. I think we should think about that, because this isn't focused on just the current administration. It's focused on how we make appointments to this very critical commission. We have a lot of commissions that appoint members with confirmation of a Senate. Some of them may not even have the same critical nature as what this one has. I don't know why it was missed during the creation of the commission back in either 78 or 80, as was mentioned. But nevertheless, political fortunes change, political spectrums, that pendulum that swings back and forth changes as well. And I think this bill brings a little bit more participation and transparency to the process of the appointments to this particular commission. We're not changing the membership. We're not altering that at all. Governor, we just want, I think it's wise for elected officials to have a few fingerprints on the membership and appoint them. We appoint a lot of things, and this is no different. Thank you, Senator Limmer. Mr. Reeds, we probably got the table up front there. If you have anything to add to 2.5 through 2.7, I'd be happy to hear it now. We can keep kind of the global perspective out of it. Right now, we want to make sure we're focused on this. So if you would, please.
Thank you, Mr. Chair. I'd be happy to address any of the questions that have been raised. With respect to Senator Bigham's, except for Senator Bigham's question, which was to give my opinion about this bill, I can tell you that the Sentencing Guidelines Commission has not taken an opinion on this bill. In fact, nobody on this commission asked that they take an opinion, so I respectfully decline to insert my personal opinion into this conversation. With respect to whether there's been more crime and more probation, I would refer the committee to a couple of points in the report to the legislature that we gave you. One is footnote 44, which states, so we don't have access, we look at sentencing information, so we don't look at crime data that's reported up from the police departments to the FBI, and then, but looking at that information from 2019 to 2020, the index crime rate rose by 3.1%, which was still a little bit over half the 1990s rates. So at least in 2020, which was from the most recent report from the Minnesota Department of Public Safety, it had been rising, but it was still below what the rates had been in the 1990s, as I'm reading that footnote. The other question had to do with probation information, and I would refer you to Figure 7 in the report. The blue line on that, and I'm sorry, I'm not prepared to display this today, but there's a blue line in that report that shows what the imprisonment rate has been over time, and you can sort of infer that the probation rate is everything above that line. And since the guidelines have been adopted, the probation rate, or the imprisonment rate, has been at about in the 20s, basically, in the low 20s. It hasn't really gone up that much over time. What's interesting about that chart is that the presumptive prison rate, so the part that the lever that the Sentencing Guidelines Commission would control, has gone up over time. It's sort of been a gradual increase, and there's been sort of a rising differential there between the actual imprisonment rate and the presumptive prison rate. But I don't think you can say that probation has necessarily gone up or down over time. That's been fairly static, shockingly so, over a 40-year period. If I may, Mr. Chair, just a couple of points of clarification as far as the Commission's authority vis-a-vis the legislature. It sounded like something that was of interest to the Commission. Or I can stop, that's fine.
Mr. Reeds, if you believe it's regarding the bill here and what the relationship is between the legislature and the commission, I'd be happy to hear it.
I think so, Mr. Chair. So it had to do with, well, there was a question about whether the commission's decisions are unanimous. I would say generally they're unanimous. There have been a couple of notable, including the decision last month to not to go forward on the repeal of the custody status point. That was not at this time, as was pointed out. That was a unanimous decision. The drug offender grid, the creation of the drug offender grid, was not a unanimous decision. That was, I think, sorted out by the legislature, and the probation cap was not a unanimous decision. So I would say in the 7.5 years that I've been here, those have been the two major exceptions to the rule. The general rule, as Senator Bigham correctly pointed out, is decisions generally tend to be unanimous or nearly so. With respect to the interaction with the legislature, the commission typically proposes changes to the sentencing guidelines by January 15th, and then the legislature has 7.5 months to take action to override that. So as Senator Matthews pointed out, this is not a commission where the commission advises the legislature. Rather, it's the commission where the legislature has an opportunity to override. But it does not automatically go into effect until a legislative session has passed. There are some exceptions to that, particularly like if the legislature creates a crime, we have to rank it, otherwise it won't be ranked. So we do take action and report that after the fact. But for most significant changes, it is reported to the legislature. The legislature has 7.5 months to take action or not. And if not, it goes into effect.
Thank you, Mr. Reeds. Appreciate that. Senator Bigham.
Thank you, Mr. Chair. I have a question for the author. If you're good?
Senator Limmer.
Okay. I just want to make sure the public understands this correctly, and if not, like, let's get some clarity for it. The said, in the language here, appointees would be appointed, able to do their job as they're doing now, subject to the confirmation of the Senate. So this is just like the commissioners currently, that process, that the governor appoints and then the Senate makes a decision. Is that the process that you're moving forward on this bill?
Senator Limmer.
Mr. Chair, thank you. Senator Bingham, yes, I believe that's the direction we are going in. We have a board, I'm not sure if it's exactly like a commissioner appointment, but it would be reviewing backgrounds, discussions of how they approach particular issues, get a feel for who would be on that membership.
Mr. Chair.
Senator Bingham, follow-up?
Yeah, so in other words, nothing will change because the governor's going to appoint who he wants. We don't confirm anybody or they sit on a docket and they still get to do the work. They're still going to do the wonderful report that was a day early. To us, they're still going to get to do all of that. I'm going to reiterate my suggestion that this be done statutorily. If there is accountability, if there are tweaks and revisions that you want that I think will be substantive and actually make a difference, I think that is the discussion that this committee specifically should have, and I'm ready for it. Love to have it and love to engage folks in it. This isn't going to change anything because the governor is still going to get to appoint whoever he is, just like when you guys don't confirm a commissioner or get rid of them, which has happened this session or during this tenure. They appoint another one and that person does a job. And so, I mean, it's like a cycle. So I think my point is if you want substantive change and you think as the governing majority party in this body that this is the right way to go, I think your expectations are going to fall short. And that of communities are going to fall short as well, because I don't think this is going to have the change you expect it to. And I'm, again, willing to have the discussion about reforms on Sentencing Guideline Commission and willing to do it. So I hope somebody over there takes me up on that.
Mr. Chairman.
Thank you, Senator Bingham. Senator Limmer, I was going to say one thing before you move, but if you'd like to.
Mr. Chairman, I just want to make a comment responding to Senator Bingham.
Please go ahead.
Senator Bingham, I know you haven't been in the Senate long, but over the years I've been here, I've noticed that the other political party has not confirmed certain commissioners based on what I would consider mere philosophical approaches to particular issues. And saying when you guys do not appoint, that can be broadly presented to both parties. We're trying to bring a sense of knowledge and transparency to this appointment process. Having perhaps a hearing on reviewing membership when necessary is important for the public to know who's on these commissions. If you're not in favor of transparency in this manner, don't vote for it. But quite honestly, we could have considered removing the whole commission. We could have played around with who's on the commission. I thought this was the least amount of attention to this process and at the same time bring transparency for the public to understand. I think it's pretty hard. You must have a better crystal ball than I do in saying nothing's going to change. Because quite honestly, I don't think anyone has that power. And so I think I'm ready to move the bill, Mr. Chair, but quite honestly, we'll see how it stands. We've got a long process ahead. It's on our schedule today. I'm not sure, as Senator Latz asked, what the House is going to do with it. But we run these ideas up the flagpole and see what happens. It's good public discussion. Mr. Chair, I move Senate File 2672 as amended and to be moved to the State Government Committee.
Thank you, Senator Latz. Before we get to the roll call, I'd like to mention that a quorum is present. So, Ms. Petrus?
Mr. Chairman,
Senator
I
Latz.
think you had acknowledged that I had a question after Senator Bingham was going to speak. I wish to do that before we vote.
Okay. Senator Latz.
Thank you. Mr. Chairman, Senator Limmer, in your opening remarks, you indicated that you thought the Guidelines Commission was violating some statutes
Was
by some
what?
of their proposals, violating some statutes
I
by some
didn't
of
say
their
violating
proposals.
statutes, Senator Latz.
Okay, so you're not suggesting that any of the actions the Guidelines Commission has taken has violated any statutes, is that correct?
Senator Limmer.
Senator Latz, I believe they're working under the authority that they have. I'm questioning whether or not the membership in going in certain directions should have had a little more vetting. And I'm offering this as a suggestion on how to anticipate that in the future.
I appreciate that clarification, Senator Limmer and Mr. Chairman. I would note that I don't see how this changes transparency in any way. There's nothing that hides the qualifications or the names of the members. It may change the legislative oversight, but it won't change any transparency in the process. Thank you,
Well, Mr. Chairman,
Senator Limmer.
I believe it does bring transparency, but more importantly, it brings accountability to the process. Accountability in regard to including those who are elected in office to be a little more responsible of who becomes a member. And I think it's a relatively simple approach to have a little vetting and a little confirmation of these members on this commission.
Okay.
Mr. Chairman, I renew my motion.
Very good.
Mr. Chair, if I could. Mr. Chair, just one real quick
Senator
comment
Ingebrigtsen.
with regards, and I wasn't able to ask the question of the director, but what's troubling to me, and we can certainly do this offline, Director, is that you said that the commission does not look at crime stats, and then afterwards you said when the legislature passes a bill, then you have to look at, of course, the statute, and you have to rank the crime. I'm not sure how you can do that without looking at crime stats and how you can, how this group can actually come up with any departures, whether upward or downward, without looking at crime stats. I don't understand that. Maybe you can point that out or clarify that for me just real quickly.
I think that's something that's off bill here a little bit. Let's take that conversation offline. We've got a deadline here we have to make, but thank you, Senator Ingebrigtsen.
I renew my motion, Mr. Chairman.
All right. Roll call has been asked for. Ms. Petrusa, please run the roll.
Chair Limmer,
Aye.
Senator Anderson,
Yes.
Senator Bingham,
No.
Senator Ingebrigtsen,
Yes.
Senator Johnson,
Yes.
Senator Kiffmeyer,
Aye.
Senator Latz.
No.
Senator Matthews,
Yes.
Senator Pappas.
No.
There being 6 yeses and 3 noes, the motion prevails, and this is moved on to state government. Thank you, Senator Limmer.
Mr. Chairman, I also have Senate File Number 2669.
Senator Limmer brings forth Senate File 2669. Senator Limmer, to your bill.
Thank you, Mr. Chairman. Perhaps we'll have a little bit more unity on this one. Senate File Number 2669 simply provides for classified employees of the Minnesota Sentencing Guidelines Commission. Right now, the commission personnel consists of an executive director, a management analyst, and 4 research analysts. All 6 employees serve as unclassified state employees. The bill changes their employee status of the commission staff, but not the executive director. from unclassified to classified. I know that Mr. Reitz also is, or Executive Director Reitz is also here, and he may want to add to some of the comments.
Mr. Reitz.
Thank you, Mr. Chair. My name is Nate Reitz, and I am the Executive Director of the Minnesota Sentencing Guidelines Commission. Thank you for this opportunity to testify in support of Senate File 2669, the bill to give the 5 state employees whom I supervise the employment protections that come with classified service. When I accepted this job 7.5 years ago, I was well aware of the excellent customer service reputation that the MSGC staff had earned. When you called, a friendly, well-informed human would answer the phone with accurate and helpful guidance. When you asked for particular sentencing data, you got a tailor-made data report quickly, accurately, and professionally. I knew before I started that my primary goal must be, and still is, not to mess up that excellent reputation. The 5 analysts on the MSGC staff model the best of what it means to be a state employee, and it is on behalf of these outstanding public servants that I testify today. In the last biennium, as I was researching options to meet what then appeared to be a looming agency budget crunch, I was surprised to learn that because MSGC staff members are statutorily unclassified employees, they are not eligible for layoff. In the event of a budget shortfall, their appointments would simply be terminated, with no assurances of reappointment once funding resumed. In addition, unclassified employees are ineligible for protections against at-will termination, making them essentially always in a probationary status. This bill updates a statutory provision that goes back 44 years when the Minnesota legislature created the nation's first Sentencing Guidelines Commission. When it did so, the 1978 legislature made the entire staff unclassified, as Chair Limmer pointed out, for reasons that are not obvious today. These 5 analysts do not fit the ordinary mold of unclassified employees. They are not elected. They are not agency heads or deputies. They deal in public data and policies, not confidential commission deliberations. They are not required to be loyal to a particular commission, but serve impartially under a new commission as often as every 4 years. And they do not report directly to the commission, as I do. Finally, they are certainly not temporary employees. Among the 5 of them, the average length of state service is 20 years. This bill corrects this outdated provision of the law by simply making these 5 analysts regular classified state employees, giving them the same protections that nearly every other MAPE contract employee enjoys. This no-expense, common-sense, entirely non-controversial bill is supported by me, by the 5 employees themselves, and by the Minnesota Sentencing Guidelines Commission, which wrote in last year's report to the legislature, quote, "Because MSGC staff require a great deal of specialized technical expertise where continuity is vital, these 5 positions are long overdue for the employment protections that come with classified service," unquote. In short, this bill is the right thing to do by these fine state employees. Mr. Chair, on behalf of the Minnesota Sentencing Guidelines Commission, I thank Chair Limmer and Chair Kiffmeyer for authoring this good bill, and I respectfully ask for the committee's support.
Senator Limmer.
Thank you, Mr. Chair. I just wanted to add a few comments about your staff, Ms. Reitz. We send a lot of requests to them, and you are correct. They give us amazing results in a very speedy manner and very complete. I would venture to guess that these are some of the best employees and public servants that we have in the state of Minnesota. And I just want to mention their names if I could. Ann Wall, Jill Payne, Linda McBrier, Kathleen Madeline. I may have trouble with the last name, Shauna Mahabir. Am I right in that?
That's right, Mr. Chair.
Like I said, some of these people, as you mentioned, have been working with the state of Minnesota for literally decades. And we are so appreciative of their work. I'm glad this request was brought to us, and we can make them classified state employees.
Thank you, Mr. Chair. I'll pass along those generous comments
you.
to my staff.
Appreciate that.
Senator Kiffmeyer.
Thank you, Mr. Chair. Appreciate you being here today. You've mentioned that this is a commission that has been in place since 1980, I think it was. But for the employees who are there now, I think into the realm of 20 years. Is that right, that they've been there around 20 years, these same employees?
Mr. Wright.
Mr. Chair, Senator Kiffmeyer, that's literally the average. So that's including the Shauna, who just started 2.5 months ago. Three of the employees have been in state service for 20 years or longer. And one has seen most of the sentencing guidelines era and is probably going to be retiring, unfortunately, soon.
Follow-up
Senator
question.
Kiffmeyer, yes.
Thank you, Mr. Chair. And so during that period of time, has this been a problem for them?
Mr. Wright.
Mr. Chair, Senator Kiffmeyer, it has not. I think only a fool would, and none of my predecessors nor I hopefully have been fools, would fire these outstanding staff. But I will say last year when we were hiring for an unusual vacancy in our staff, I felt like it put me at a competitive disadvantage vis-a-vis other state employers and frankly other employers in general to have to tell these people that you are basically at-will employees because the staff of the Minnesota Sentencing Guidelines Commission are unclassified. So that's probably the main impact. And then the other impact was when we had that anticipated budget crunch, their appointments were going to be terminated. They couldn't bump anybody else in a layoff situation. Because they're unclassified employees, they just have their appointments terminated and hopefully reappointed once we get funding again.
Thank you, Mr. Chair.
Follow-up?
No, thank you, Mr. Chair.
All right, any further questions? Senator Limmer.
If there are no further questions, I would move Senate File 2669, be recommended to pass, and move to the state government. And for the record, if anyone needs to know.
Mr. Chair, we can't hear Senator Limmer. He's on mute.
Oh, thank you. Senator Limmer.
Thank you, Senator Pappas. Usually Senator Bingham catches me on that.
I had my mic
Slow
down.
on the draw.
Before I make the motion, if anyone is curious to know, there is a House bill, Representative Pinto is representing this bill. And with that, Mr. Chair, I move Senate File 2669 be recommended to pass and move to the State Government Committee.
All right. All those in favor of Senate File 2669 indicate by saying aye.
Aye.
All opposed?
Aye.
Bill passes and moves on to the State Gov. Senator Latz.
Mr. Chairman, apropos of the previous bill's conversation, I've received information according to the Star Tribune that the two arrested individuals relating to the Richfield shooting do not appear to have juvenile records or any criminal history in Minnesota beyond minor traffic violations, according to a law enforcement source.
Thank you for that. Senator Limmer, do you want to give any closing comments about next meeting or anything?
No, not right now, Mr.
Wonderful.
Chair. We will be getting notices out on the agenda coming up, and look forward to a good working relationship with everyone between now and May.
All right. Thank you very much. Seeing no further business before the committee, we're now adjourned.